My name is John Cullen, and I want to tell you a story. It's a story about a scandal, broken relationships, gossip, rumors, money, corporate rivalry, and curling. It's the story of Broomgate, how a single broom, yes, a broom, turned friends into foes and almost killed the 500-year-old sport of curling.
It was a year I'd like to forget.
Broomgate, available now.
Frequency Podcast Network. Stories that matter, podcasts that resonate.
As you may be aware, there is a lot of anger out there towards the largest grocery chains in the country. And there have been plenty of calls for the Competition Bureau to step in, to do something, to do anything to increase competition in the industry. The question there has always been, do what exactly? Unless Canada's big grocers are engaging in unfair and anti-competitive practices, there's not a lot the Bureau can do here. Last week, though, that's exactly what it said it would look at.
Canada's competition watchdog has launched a probe into two grocery giants. In documents viewed by the Canadian press, the commissioner is looking into Loblaws and Empire. It's to decide if they are blocking competition by other food retailers, something that limits choice and can keep food prices high.
What the Bureau is investigating here is a fascinating little corner of contract and competition law that involves a practice that's used in malls and retail areas and even in homes across the country. But the way Loblaws and Sobeys are using it, the Bureau says, might well be over the line. So what is this practice? And where exactly is that line? Would it still have been crossed if these companies were not the grocery giants that public sentiment is very much against? What happens next? And how much might Canadians learn about the power these companies can wield when their business is at stake? I'm Jordan Heath Rawlings. This is The Big Story. Jennifer Quaid is an associate professor at the University of Ottawa's Faculty of Law. She is an expert, among other things, in corporate accountability, competition, and business regulation. All of that relevant to what we're going to discuss today, Jennifer, in relation to Canada's ongoing issues with its grocers.
Indeed. It's going to be an interesting conversation.
Well, this isn't the first time the Competition Bureau has gotten into it here with Canada's major grocers. Can you sort of refresh us all on what they've previously said about the sector? There
is a fairly long list of items that have attracted the attention of the Competition Bureau, which is our regulator of competition at the federal level. I suppose the first thing, chronologically anyway, that attracted attention was when Loblaws in 2016 came forward to the Bureau under their immunity and leniency program and admitted to being part of a price-fixing cartel with other major players in the retail bread sector. That confession, if you will, to the Bureau then prompted an investigation that is still ongoing. There has been one other player. People may remember last year, just about a year ago, Canada Bread pled guilty in the context of that arrangement. Loblaws got immunity because they were the first in. And, that certainly did not make people happy to discover that on a basic staple, the grocers had been getting together and setting prices.
Right.
Following that, in the first few months of the pandemic, people may remember that there was a concept of essential worker. And among the essential workers who still had to go into work and work in person when the rest of us were all masked up and hiding at home were people who worked in grocery stores.
Right.
And in part in recognition of the fact that these people were going into work at a time when we were all deeply worried and didn't really understand, how contagious COVID-19 was and how much of a risk it was. They were paid a bonus extra over their salary. And one has to recall that, frontline grocery workers didn't make a lot. They were making maybe minimum wage or a little bit more. So it was considered to be a good gesture on the part of their employers, who were the big grocers.
Uh-huh.
Well, in July 2020, so just a couple of months later, there was a fairly well-coordinated withdrawal of what was called hero pay, this bonus. And at the time, people were, first of all, appalled that it was being done, but second of all, quite struck by the fact that it occurred all at the same time.
Right.
And some people said, well, how is it that they all knew they were withdrawing hero pay at the same time? Well, because they talked to each other. And then came the obvious follow-up question, which said, how come they're allowed to talk to each other about this? Isn't that something that they shouldn't be doing? Isn't that like cartel behavior? And although that is true, that it is communication among competitors, at the time, Canada's law did not cover arrangements between buyers of services and product. It's a change that was made to the law in 2009, and therefore the behavior of these grocers was not covered by that. But it did light a fire under the movement to add a wage fixing prohibition to the act, which happened then in 2022. The next thing that brought the grocers on,
it's a lengthy list.
There's a long list. The next thing was there was some focus being brought on how they used what are called restrictive covenants. They're basically clauses in contracts, but in this particular case, mostly in leases. So arrangements where, a tenant is going to rent space from a landlord, typically a commercial landlord that owns a mall or something like that. And that because the large grocers, in particular Loblaws and Sobeys, through their parent companies, Empire and Weston, are able to own interests in real estate income trusts. And therefore, they sort of have a kind of their foot in two sides of it. On the one hand, they're the landlord, and on the other, their subsidiary grocery entities are tenants in those same malls. There was some evidence that they were using these clauses to restrict how other grocery stores or other grocery tenants could use the space. And I guess the case that blew up, or that got a lot of attention last fall, was a case in Nova Scotia involving a Dollarama that was told it couldn't stock certain products and it couldn't price certain products below those of the Sobeys that was within a certain vicinity. And the problem for Dollarama is that its business model is based on the idea that it has a very small offering of products, but it really deeply discounts those.
Right.
So if you're not allowed to offer that product, it's not like you have 10 others you can offer. So it was a big deal for them. So that precipitated a lot of attention on what was called restrictive covenants. And there was actually a change to the Competition Act made in December. The other thing that didn't put the grocery stores in anyone's good books is that the Bureau last summer tried to do a market study of the sector. And at the time, it did not have the power to force those that it was studying to share information with it. It was voluntary.
Right.
And I guess the grocers were not very willing participants. And one of the things that was noted in the Bureau's report is that they did not get all the information they wanted. That power to compel information has also subsequently been the subject of a change to the Competition Act that now allows the Bureau to go after it. So that's just a couple of examples. I mean, the other is that they famously were all brought into one room by Minister Champagne and sort of told to behave. I mean, I'm not sure what that happened, but they've been in the news a lot and generally not favorably.
And now the Competition Bureau, and this relates to, I believe, one of the incidents you just mentioned, the Competition Bureau has launched actually an official investigation. Into what and who exactly is it investigating?
Based on what we know now, and the source of that information is not something I've been able to look at directly, but these are requests made to the federal court. It's a power that the Competition Bureau has to go to the federal court and say, we have reasons, to believe that there might be something worth investigating. Here are the people or the companies where we want to investigate and from whom we need information. They get that order and then they can demand the information. So that's the only thing that's happened so far is they have sought these orders. They're called Section 11 orders, not very creative. And they've sought them against Empire and against Weston, as far as I know. But it includes also documents in relation to Sobeys and Loblaws. And what they're looking at in particular are these restrictive covenants. So they're looking at how are clauses in lease agreements being potentially used as a way to restrict or otherwise impede the activities of competitor grocers.
Let's talk a little more about these restrictive covenants, because these are really interesting things that I think myself included and a lot of our listeners, until the grocers were accused of using them, didn't really know they existed. So how common is this practice? And, how is it intended to work?
So the short answer is that restrictive covenants are pretty common. And in fact, there are probably homeowners who've discovered there are restrictive covenants on their properties.
Oh, interesting.
These are basically contractual restrictions that are put on uses that can be made of usually a piece of land or a building. And sometimes those things actually are not really well noticed, and the property can change hands and those restrictions can keep following along. More specifically in the context we're talking about here, which is the commercial sort of leasing context, you could see why restrictions on the use of land or of the building would make sense. When you have a mall, you want to make sure as a commercial landlord, you have a mall that makes sense. You've got a mix of products, or you've got a mix of stores that kind of meet the demand, that fit with the neighborhood and so forth. So you do want to make sure that you don't suddenly have your tenants doing things that are wildly different from what you expected when you rented to them. Also, just in terms of how you might present your store and fit in with the overall look. So some of those don't really seem unreasonable on their face. It's when you start getting into kind of the details in terms of business decisions you might make, pricing decisions you might make. That's where perhaps there's a line that starts to be crossed. I don't think you can across the board just say all restrictive covenants are bad. And I think there are many good and legitimate commercial reasons why even you might have some even restrictions on pricing or other practices. But I think that now there has been a particular set of circumstances that have been identified in a sector where there are already concerns about the ability of the smaller group of largest players to dictate the terms of the market to the smaller players. So, there's a couple of factors that are adding up together that means we want to take a closer look at this. That's not the same thing as saying that there is, in fact, a problem, or that we can connect the dots and say using these restrictive covenants will lead to a competition problem. But there's at least reasonable grounds to take a look.
Is there actually a line? Like, are there any hard and fast regulations around what can and can't be in these restrictive covenants? Or is it just kind of the Bureau is making judgment calls, or perhaps saying we need to draw that line?
So this is an interesting question. I will try to answer it with the caveat that I'm not a contract law specialist, and so I can't assert generally something about restrictive covenants, everywhere all the time.
Right.
But restrictive covenants are contract clauses. Contract law is, at its base, an area of provincial jurisdiction governed by provincial rules. So each province sort of sets the terms under which contracts can legitimately be made. The basic premise, these are generalizations, but let's say for the purpose of people understanding, generally we believe in freedom of contract, and especially between commercial players, where there is an assumption of an equality of bargaining power, at least in theory, right? In the consumer context, we recognize there's an asymmetry of power, and there are additional protections, usually contained in laws, but sometimes they also come from court decisions that assess, the fairness of certain circumstances, where we say the pure freedom of contract is not available. There's some very, very small circumstances where even in a commercial context, you could say you're not allowed to do certain things. And clearly, you're not allowed to have restrictive covenants that are illegal, like against the criminal law or against, existing rules. There might be circumstances where it's just, goes against public policy in general. Mm-hmm. But I would say there's a fairly wide range within which contracts can be freely negotiated. And the idea is you get what you negotiate. It's up to you to advocate for your interests. And that's very closely related to our idea that, there should be freedom with a small f, but freedom of people to arrange their commercial affairs as they see fit.
Right.
The idea of the Competition Bureau taking a look at restrictive covenants has received some flack from members of the business community, but also the legal community, who say, hey, wait a minute, there are already rules that govern contracts. There's already, a whole area of law. Like, why are we going in here and fussing with this? If there's a problem with restrictive covenants, it should be solved in contract law and not through competition law.
I'm Laura Palmer, host of Island Crime. Season 6, Sweethearts, is the story of 3 teenage girls who were all murdered in Victoria, Canada, within about 12 months.
So she was scared. Something out there scared her.
You just created the playground
where predators can really thrive.
She was a 16-year-old girl. She was a sweetheart.
Listen to Sweethearts at frequencypodcastnetwork.com or wherever you get podcasts.
Find your frequency.
Would we even be having this discussion if it wasn't gigantic grocery chains doing this thing, given the previous history that you've illustrated for us?
Certainly, I think there's a little bit of that going on. There were some news reports that came out that suggested that Empire actually cast some aspersions on the Bureau and its motivations and said, this is politically motivated. This is because there's pressure to react to the grocery sector. It's actually a lack of independence and so forth. I don't think that the assertion of lack of independence of the agency is a fair comment, but there's no doubt that there's a lot of attention on the grocery sector. It is a very concentrated sector, and there are very large players who have behaved badly in the past, and there is a lot of attention being focused on affordability. So that makes a powerful combination for attention on these practices. I don't want to suggest that the Bureau is wrong to look at these things. I want to underscore that there are some who say this isn't the right way to go about addressing this issue and that one should be careful about being too broad-stroked. I think the other thing to stress is that part of the issue here is that you have within these large grocery concerns, they're actually, multifaceted businesses with lots of different lines of business within them. And this real estate holding component is one of them. It isn't the largest part of the earnings, but I think one of the concerns is the fact that you've got essentially someone on both sides of the lease, both the landlord and the tenant, and that creates a unique position for essentially someone who's interested in the grocery store, the Loblaws or the Sobeys, who can then sort of tell the landlord, yeah, and let's make sure we reinforce that position. That's the suggestion, right, is that there's some sort of conflict there. Remains to be seen if it's established.
Beyond what you just mentioned Empire saying about, perhaps this investigation being motivated, have Loblaw or Empire said anything about the Competition Bureau's investigation specifically and about these restrictive covenants and what they think of them?
Their basic answer has been a little bit along the lines of what I've already said, which is, look, these are legitimate commercial arrangements. They're negotiated between parties who are both negotiating in their interest.
Right.
And there is a legitimate commercial purpose for them, and that they are not motivated by the intention to restrict competition. I think the other piece that they're also trying to put forward is to say, even, if that were the case, these arrangements don't result in a diminution of competition. And under the Competition Act, it has to be a substantial lessening of competition before there's a basis to intervene, at least in civil matters. And these are being characterized as civil investigations. So, there's a threshold you have to meet. And from what I've heard, that there's sort of two prongs of attack. First of all, there's nothing wrong with what we're doing. And second of all, it doesn't cause a competitive problem.
So now that this has begun, you mentioned the Bureau has made requests for information. How does the Bureau actually perform these investigations and what will happen? And I guess how transparent will it be?
The first thing I have to say is that Bureau investigations are conducted in private.
Okay. Well, that answers the last part of that question.
Yes. So they are bound to a fairly high level of confidentiality because they're dealing with sensitive business information, but also their investigations can have ancillary or, accessory impacts on the businesses while the investigation is going on. And so they're conscious of that. You don't want to be influencing the market or, disrupting business operations because until the investigation reaches an end or there's a conclusion reached, all they're doing is looking at something and you wouldn't want to destabilize the sector. So that's the first thing. The Bureau will acknowledge, when there are public things that happen, that it's doing those. So for example, it did seek information from these parties through Section 11. Those are public court documents. You can go to the registry and get them. They're not available online. It's not easy to get access to them, but you can get access to them. And if they, for example, filed an actual application before the Competition Tribunal, well, they would issue a press release to say, we have decided to proceed and we've filed our application. But they won't generally comment outside of that because they don't want to create that disruption. The timeline is hard to predict.
Right.
That is a little bit a product of how extensive the investigation is, where it takes them. So they've started first with their targets. That's pretty normal. Then they're going to go on and talk to other players in the market, to customers, to suppliers, to others who may have information they need. They will probably hire experts who will do analyses of that's really getting into the weeds, but, what is the connection between these covenants and impact on the market? There's some pretty complicated math that gets involved there. And when they put that all together, I'd say it's several months at least, if not a year, then they make a decision. Do we have enough to move forward? Can we establish that there's a substantial problem or not? Throughout this entire process, it's also possible, as with any investigation and any sort of thing that ends up being potentially litigious, for an agreement to be reached with the targets. So in this case, they might agree to a consent agreement with Sobeys, Empire, and or Loblaws and Weston, which says, look, without admitting anything is wrong, that's always how it starts.
Yep.
We're going to do the following things. And that might be agreeing to restrict the use of the covenants, maybe not do certain types of restrictions, or to limit those restrictions to certain circumstances or certain areas of the country. All of that will be driven by what the facts are on the ground. It's hard to speculate in the abstract, but that's always a possibility, that they reach a kind of settlement without having to go to court. But ultimately, if the Bureau thinks they've got enough, the other side is not interested in making a deal, they will end up before the Competition Tribunal. And I guess depending on the amount of attention that is focused on it, maybe we'll have something similar to what happened in Rogers Shaw, which was a merger case, not a case of competitor collaboration. And maybe everyone will be watching it on Zoom. It's always interesting when there's a public light being shone on the proceedings. I think that draws a lot of attention. But we are a long, long way from that.
Right.
At the end of the day, if the tribunal decides, yes, Commissioner, you've proven your case and there is a competition problem that's substantial, then the question of remedy comes up and the court has quite a lot of freedom to decide how they will address that. The big question for me is that this provision of the Competition Act, which doesn't really have a convenient name, it's Section 90.1, but it deals with sort of cooperation and collaboration between competitors and others.
Okay.
But not cartel behavior. So it's not criminal cartels, but it's kind of like when competitors seem to get together for reasons and it causes a competitive impact. This provision's never been tested before the courts. It was added to the Act in 2009, but over the course of the past 2 years, in the context of this competition reform that's been happening, it's been modified 3 times. And in fact, is still under modification because the third part of the reform is still before Parliament, hasn't been finally enacted. And although normally I would say at this stage, probably the text will say the way it is, we've seen some weird things on Parliament Hill the past year where bills get changed at the last minute and so forth. So I don't know the final word. But one of the things that's interesting in that provision is that it's planned to add a private right of action under this part of the Competition Act, which would mean that if the Bureau decides not to go forward, others could seek permission from the tribunal to bring a lawsuit themselves. Now, they don't have the same tools available. They're not allowed to seek administrative monetary penalties. And so they have some restrictions on the things they can get. But that might be potentially another avenue. That provision would not come into force for another year if the bill is passed now. So it's not something that could be done right away, but something to keep an eye on. So this area of law is also not well developed and is changing. So there's quite a lot of uncertainty around what's going on.
Well, that's my last question, which is, the public may not see a lot of this over the next little while, but as this process plays out, as someone who studies this area, what will you be looking for as we go to give you a sense of whether or not this may turn into the process that you've just described, or will it just be totally opaque until one day, like a press release goes out and here we are?
Unfortunately, unless you are someone who works for the Bureau or part of their legal team, in which case you're sworn to silence,
right?
You're not going to find out anything until the Bureau actually announces that it's proceeding or announces that it isn't proceeding. Now, if ever a private party takes carriage of the case, let's speculate into the future, well, then, of course, that private party can decide how it wants to manage the communications around its case. But generally, in litigation, parties are careful about how much they talk in public because they want to keep their strategy to themselves.
Right.
But yes, unfortunately, we are beholden to the willingness of the Bureau to share information about its investigation and litigation. And typically their base position, which is prudent, is to say less rather than more.
Well, thank you so much for this. It's really fascinating to delve deep into this, and I feel like I learned a whole lot about the way retail space works today.
Well, thank you very much. It was a really interesting conversation.
Jennifer Quaid from the University of Ottawa's Faculty of Law. Been a lot of lawyers on The Big Story recently, and I have to say, I am learning an awful lot about how things work behind the scenes. That was great. For more from us, including previous episodes about little fascinating corners of law, you can head to thebigstorypodcast.ca. You can also leave us feedback, whether you like or dislike lawyers. I feel like I'm setting myself up for a joke here. I don't have a joke. I just have ways that you can get in touch with us by email, hello@thebigstorypodcast.ca, or with a phone call and a voicemail left at 416-935-5935. This show is available in every single podcast player, and it is available on your favorite smart speaker. You just need to ask that speaker to play the Big Story podcast. Thanks for listening. I'm Jordan Heath Rawlings. We'll talk tomorrow.